Cadwell, and I am the statewide Title II ADA coordinator for the New Mexico Administrative Office of the Courts. We are happy that you can join us today for this very valuable presentation, How to Identify Service Animals, with our presenter, Jeminie Shell, who is a disability specialist with the New Mexico Governor's Commission on Disability. Before we get started with the presentation, we have a few announcements. First, we would like to ask you that if you do have questions, please go ahead and enter them in the chat. Jeminie will try to get to those after her presentation. We will be recording today's presentation, and after the session today, we'll post that on our YouTube channel. And we will be giving you a link to that YouTube channel, and we'll put that in the chat as well for everybody. As a reminder, these presentations are for informational purposes only, and what we cover today is not meant to represent any type of legal advice. Again, thank you everyone for joining us today. We're happy that you could be with us in New Mexico and across the country. And please help me welcome Jeminie this afternoon. Jeminie?
Oh, thanks, Peggy. Thank you so much. Good afternoon, everyone. It's barely afternoon, at least here in New Mexico. Thank you all for being here. We sure appreciate your presence. Again, as Peggy said, I'm Jeminie Shell. I work for the Governor's Commission on Disability here in New Mexico, and I'm a disability specialist. And one of my areas of specialization is service animals. I have responsibility for a lot of other programs as well. I do want to share one thing with you. Everybody in the country has access to the ADA Coordinator Certificate Program. That's also called the ACTCP. It's actually ADA Coordinator Training Certificate Program. That's out of the Great Plains ADA Center and University of Missouri. We in New Mexico do lots of trainings for that program, and we have a scholarship that we provide from our agency for New Mexico residents, both under Title II and Title III entities, so that people can get trained and certified in ADA coordination. Feel free to contact me directly if you're interested. If you live in New Mexico, I should say. The scholarship is only for folks in New Mexico. So if you do live in New Mexico, please get in touch with me. I know a lot of you at the courts have actually already gotten certified. Good for you guys. Congratulations and well done. And then we do have some more who are interested in getting certified already. So I welcome you to the program and look forward to working with you. Now we're going to move on. The agenda here, and actually I'm going to, well, I'll just leave my camera on. I was going to turn it off so we could focus on the slides, but I'll just go ahead and leave it on. So here's our agenda. First, we're going to talk a bit about laws related to service animals, and we'll be focusing mostly on Title II of the Americans with Disabilities Act. Of course, all the courts do fall under Title II as services under state and local governments. Then we're going to move on to what I like to call a deep dive on service animals, and we're going to take a look at how to differentiate between different types of animals, what service animals do for their handlers, what types of tasks they perform, how to identify a service animal. That's the big takeaway from this presentation today. The rights and responsibilities of the service animal handler, and the rights and responsibilities of Title II entities. We'll also talk about one ADA complaint, and we're going to have a little quiz if we have time. So listen carefully. All right. The laws we'll be talking about today are the Americans with Disabilities Act, or ADA, the Fair Housing Act, just briefly, because I want to give you some context for service animals. We're going to talk about the Air Carrier Access Act, also a separate law that has service animals included, and then one that's often forgotten for us here in New Mexico, the New Mexico Service Animal Act. Our primary focus today, though, is the ADA, and I do encourage all of you who are not in New Mexico to look at your state laws related to service animals, because most states do have additional laws related to service animals that often provide additional protections beyond what the ADA provides. So that's really critical for you to know about. So first, we're talking about the Americans with Disabilities Act. The ADA is a civil rights law that was passed in 1990, and then it was amended in 2008 to further define disability and some other aspects of the law. It has 5 sections, which are referred to as titles. Title 1 is employment. Title 2 is state and local government, which includes all services to the public, including public higher education. That is, again, public, not private higher education. Title 3 is public accommodations, which is businesses, nonprofits, medical facilities, private schools, hotels, stadiums, all those sorts of facilities or entities that are not governmental related. And then Title 4 is telecommunications, which is the National Relay Service. And Title 5 is a miscellaneous set of regulations regarding technical stuff related to the law. So, what is a disability? Under the definition under the ADA is a a physical or mental health impairment that substantially limits one or more major life activities. But that's not all. It also includes a person with a history of such an impairment, a person regarded as having such a disability, and also any person associated with the person with a disability. This applies to all titles under the ADA. And for instance, a person with a history of a disability might be someone who is in remission from cancer. A person regarded as having such a disability might be someone who is rumored to have HIV but does not. And then a person associated with the person with disability might be a parent who has a child with a service animal. And again, this applies to all titles under the ADA. So Title II is state and local government, and Title III is public access. The Department of Justice enforces both Titles II and Title III. The definition of service animal is shared between Titles II and Title III. Title I, which is employment, as I mentioned, does not have a definition for service animal. It's very separate, very different from Titles II and III. But under Titles II and III, the definition of a service animal is a dog or miniature horse that is individually trained to perform tasks or work for the benefit of a specific person with a disability. And that means that it's only trained to work with a single handler or a single owner. Under Titles II and III, the ADA requires all state and local governments, businesses, and nonprofits that provide any programs, goods, or services to the public to make reasonable modifications to accommodate people with disabilities. That means that if you have a policy that might exclude someone in some way, you have to make a reasonable modification or an accommodation under the law in order to give access to that person with a disability. Allowing service animals is considered a reasonable modification of a no pets policy, for instance. That's a good example of this reasonable modification. Now we're going to talk about the Fair Housing Act. You may have heard that the laws related to housing, animals and housing, are different from the ADA, and that's true. The Fair Housing Act is the law that covers housing, and it's enforced by the Office of Fair Housing and Equal Opportunity, and that's under HUD, Housing and Urban Development. It defines what it calls assistance animals as an animal that works, aids, or performs tasks for the benefit of a person with a disability. And this is the key on this one, or that provides emotional support that alleviates one or more identified effects of a person's disability. And it is very, very clear in stating that an assistance animal is not a pet. So you can see here that the definition of an assistance animal differs considerably from the ADA definition of service animal in that assistance animal covers emotional support animals. That's that key phrase there, or that provides emotional support that alleviates one or more identified effects of a person's disability. So an assistance animal can be either a service animal or an emotional support animal. It cannot be just a pet, though. It has to be required due to a person's disability. And I've included this today because it's really important to understand service animals in the context of of what other types of animals you might run into in the court. There was a question that came in by email we'll talk about in a little bit, but it really reflects the confusion between service animals and emotional support animals, and we'll talk about that. We're going to get a little bit deeper into that soon. Now, the Air Carrier Access Act, I want you to know about this too, because a lot of people think it's the same in terms of service animals and emotional support animals. It's been around for years, but the service animal final rule was actually set under the ACAA in December of 2020. I'm sure a lot of you have probably heard of people taking emotional support peacocks and all kinds of other animals on planes, right? We saw pictures in the news and things like that. Well, that is not allowed anymore. And this has to do with the fact that they have redefined service animal. So it no longer includes emotional service animals, emotional support animals. It actually is very strict and it defines service animal as a dog that is individually trained to work or perform tasks for the benefit of a person with a disability. And again, that mirrors the ADA definition. However, it also allows airlines to treat, or requires airlines to treat psychiatric service animals the same as a regular service animal. And that question that came in on email actually specifically talks about psychiatric service animals, so we'll talk about that. But the other thing that it does is it allows airlines to require certain types of paperwork to verify that an animal is in fact a service animal. But we're not going to get in depth about that. It's just an interesting aside. They can require, for instance, vaccination paperwork, which other people can't require under the ADA. We'll get in depth on that in a minute. And then finally, we're going to talk about the New Mexico Service Animal Act. This is one that's often forgotten because it's not well known about. It doesn't really have effective enforcement because nobody really knows about it. Even the police don't really know about it, and they're not aware. And so it was passed in 2013. It updated a former prior law regarding service animals in New Mexico. And again, this is just New Mexico. I encourage everybody else who's from other places in the country to look at your state requirements, because there's, I think there's about 26 or 28 different states that have additional service animal protections that go beyond the ADA. So it's important to know what your state says. So this, as I said, follows the ADA, including the definition of service animal, but it includes additional regulations as well. So there are more protections under the New Mexico Service Animal Act. That includes service animals in training are protected, the same as fully trained service animals. Emergency situations, service animals should remain with the handler or otherwise be placed per the handler's instructions. We're not going to get in depth about emergency situations, but that is something to keep in mind. And then it's unlawful for unrestrained animals to interfere with the work of a service animal or to attack one. That doesn't just require an animal to be unrestrained. Even if an animal is restrained and it attacks a service animal, it still is against the law. And then it's unlawful for a person to represent a pet or an emotional support animal as a service animal, and that's really key. Again, this has basically never been enforced in New Mexico, and I would guess that other states probably have never enforced it either. But lots of states do have this as part of their requirements. Any violation is a misdemeanor with fines up to $1,000 or a year in jail. And like I said, there's essentially no enforcement of this law. And in reality, the ADA doesn't have a ton of enforcement either. You're very lucky if you file a complaint and it actually gets taken up by the Department of Justice. The ADA, of course, is because they're the ones that enforce the law. They are the ones that get all of the complaints, and they get tens of thousands of complaints every year, and they can only handle a couple thousand, really, is what it boils down to. So I still encourage everybody to file complaints, though, because it will give them data on how many different types of complaints are out there. Now we're going to focus on Titles 2 and 3 of the ADA. That's, again, the state and local governments and then businesses are Titles 2 and 3. I'm going to reiterate that a service animal is a dog or a miniature horse where reasonable, and I don't know if I mentioned that last time, but it also can be a miniature horse that is individually trained to perform tasks for an individual with a disability. In other words, that animal engages in recognition and response to perform its tasks. Some people call that R&R. Its tasks are not passive, such as alleviating anxiety by just being there. If an animal alleviates anxiety with an active task, such as pawing at the person or jumping up in their lap when the person's anxious or having an episode of a mental health disorder, then that is an active task. So there are psychiatric service animals that are covered, but if the animal is passive and only provides comfort while being present, when no active task is handled or is performed. If no active task is performed, then it's not a service animal. Now I mentioned it can be a miniature horse where reasonable. That's actually considered a reasonable modification of the definition of service animal, which originally was only dogs. Now there's a reasonable modification that includes miniature horses. Lost my train of thought there. So which kind of animal is it? We're going to get into all the depths of ADA in just a second, but I wanted you to have this comparison first. The service animal is, again, a dog or a miniature horse that's individually trained to do tasks for a specific person with this disability. This animal has full public access rights under the ADA, which means you cannot exclude it from any space with public access. That means if the handler or the public in general can go to a specific place in a building or a business, then the animal can go there too. There are very few exceptions to this, and I'll talk about those in just a minute. Then we have an emotional support or comfort animal. That's any animal that provides passive support to a specific owner with disabilities. It has limited rights under the Fair Housing Act, as we just talked about, and as part of their definition of assistance animal. It may be allowable under Title I of the ADA, which is employment. We're not really talking about employment today. Again, an assistance animal includes both service animals and emotional support animals under the Fair Housing Act, and that's their definition of assistance animal. And then therapy or facility animals are usually a dog that's trained to interact well. With new people and new environments. It usually has completed a certification training of some sort, but it has no public access rights. Even though it's been trained, it still doesn't have any public access rights. Interestingly, though, they are found in lots of different settings. The courts often allow a therapy or facility animal. They often call it a facility animal. When there's, for instance, a child who has to testify and the child is, they're trying to calm the child's anxiety. That can be a situation where a facility animal might be used in the courts. Also, some hospitals use therapy animals to come in and alleviate people's anxiety about being in the hospital. And then schools are often using them as well, especially universities and colleges that use them for instance, midterms and finals to calm people's anxiety during those stressful times. I'm going to skip this chart because I already basically went over the details of it. Now we're going to talk about miniature horses, and I wanted to include this because the miniature horses allowed under Titles 2 and 3 are often very perplexing to people. You might kind of, raise your eyebrows and tilt your head when you hear about emotional support miniature horses. But it's really an interesting thing. Miniature horses range from about 70 to 150 pounds, 24 to 36 inches generally, and that's similar to a medium to large dog. Guide Horse Foundation, the Guide Horse Foundation only uses animals less than 26 inches. So again, that's similar to a medium or large dog. They can be trained to do almost anything a dog can do, with a few exceptions. And the really big key here is that they can provide 20 or more years of service, and the average for dogs is closer to 7 or 8 years. They're also very strong. They have a calm nature. They're very good for pulling wheelchairs, for instance, because of their strength. And it's important to note that they're subject to the same rules and considerations under the ADA for a dog. So the next thing, let's get back to the basics. What do service animals actually do? They function as an extension of the person with a disability. You'll often hear them referred to as a tool, something similar to a wheelchair, for instance. And they are a tool in the sense that they perform tasks that the person, the handler, cannot perform on their own, or has a very difficult time performing on their own. They can open doors when somebody can't slide a heavy door. They can often open doors and things like that. We'll get into the details in a minute on that. But they essentially function as an extension of the person with a disability, and that's the key. They are a part of the person, and they are absolutely critical to the person's ability to function in any setting, not just at home, not just at the store, but in every setting. They are critical to that person's functioning. Additionally, they promote independence in daily living activities and in the home. That includes also at work, but we're not talking about employment today. So let's get into depth about what tasks a service animal can perform. They used to be considered just animals that guided the blind, but that has changed significantly in the last 40 years or so. They, of course, do guide and assist people who are blind or have low vision. They also alert people who are deaf or hard of hearing to external sounds. They can guide people who are blind or low vision. They can alert people who are deaf or hard of hearing. They can alert people with a certain medical condition of the impending onset of a medical event. That would be something like a seizure or high or low blood sugar. Dogs can actually be trained to sense those medical events. Additionally, there are psychiatric service animals that can remind someone with that type of disability to take their medication. They can stop them from self-harming, or they can assist them with a panic attack by laying on their lap or on their entire body and providing deep muscle pressure. That, of course, will have to be a larger dog. Chihuahua is not going to be able to provide deep muscle pressure on somebody, but a larger dog can. And then finally, just a really important point. The service dogs can be any breed or any size, and you cannot discriminate. Horses must be the miniature horse breed. And it's important to note that it's really often not obvious what task the animal performs, and the person's disability is actually often invisible as well. Not always, but often. The good example of this that I like is a Chihuahua that's held close to a person's face, like on their chest. You might assume that person has an emotional support animal or just a pet, but that animal can be trained to alert the person to low or high blood sugar or seizures. So you can't assume just because the dog is small that it's not a service animal. They can be trained just like all other sized dogs. And Chihuahuas are pretty smart as well. So don't assume And that brings us to our next important topic, which is how to identify a service animal. Again, this is the big takeaway for this entire training. How do you identify a service animal? So if the, according to the Department of Justice's guidance, it should be a pretty straightforward process. It might not seem like it, but it's pretty straightforward. First, if the disability and the task are not obvious, are obvious, then you cannot ask any questions. If the person is blind and they have a guide dog, it's very clear what that person is doing and what that animal is doing and why the person needs the animal. So you can't ask any questions. Basically, you would be asking something that you already knew the answer to. So don't ask. On the other hand, if the disability and or task are not obvious, you can only ask two questions. Is this animal required because of a disability? And I don't recommend the wording, is this a service animal? Because of course, everybody's going to say, yes, this is a service animal when you ask it that way. So you must ask it, is this animal required due to a disability? If they say yes, then you ask the second question, and this is the key question. What task or work has this animal been trained to perform for you? It is the critical question of the two. If the answers to the questions clearly indicate that A, there is a disability, and B, there's an active task, then you may not ask any other questions. And just in a minute, we're going to talk about what an active versus passive task is. I touched on it a minute ago, but we're going to talk about it a little more in depth in a minute. You might be thinking at this point, but wait, can't I ask other questions? Do I just have to trust them based on those two questions? And the answer is yes, you have to trust them. The way that you might still be able to exclude a service animal or an animal that's being passed off as a service animal. We'll get into that in a minute. But you do have to take their word for it if they answer the two questions correctly. So you cannot ask the person about their disability or for proof of a disability. That's a big no-no. You cannot ask for service animal certification, paperwork, or registration. The important thing to know about that is that there are many organizations online that sell people these certifications, sell the vests, sell ID cards, all of this kind of stuff, and it's all fake. It basically doesn't mean anything. But if a lot of people with service animals get those things because they know that there's a big misunderstanding in the public, and they think it'll just at least help them get into places more easily. So they have a vest. But if you cannot base your judgment about an animal just because it has a vest. If it has a vest, you still have to ask the two questions. If it doesn't have a vest, you still have to ask the two questions, okay? You also have to ask the animal, or you cannot ask the animal to perform the task or ask for any other proof as training, as paperwork. Again, under the New Mexico Service Animal Act and many other states, state laws, service animals in training are protected. That is a key that people who are familiar with the ADA often don't understand, that a lot of states protect animals in training. And then also note that service animals do not have to be professionally trained. You can train your own service animal, especially for simpler tasks like retrieving items and opening doors, shutting on or turning on and off lights. You might have to get a professional training to get a seizure alert dog, though. Those are much more complicated to train. Then you cannot require that the animal wear a vest or ask why it isn't wearing one. Again, that doesn't mean anything. It just means that the person says that their animal is a service animal. You cannot request or restrict where the animal is allowed to go. If the handler or the public can go there, then so can the animal, as I said earlier. And then finally, you cannot charge a fee. I know that doesn't really apply to the courts, but I wanted to include that because it is part of the law. You can't charge fees that you wouldn't charge somebody without an animal. So say an animal had an accident in the courtroom, you can't charge them to clean that up as long as it's a real service animal. But you can then exclude that animal if it does have an accident, because we'll talk about that right now. well, not now. We'll talk about it in just a minute. So I want to talk just a little bit about the language. Not all people with a qualified service dog are going to use the ADA language to define their animal. They may even refer to it as an emotional support or therapy dog. The key then is the answer to the second question. That's why you always have to ask the second question. It's critical. You should be listening for action verbs like comforts or calms, etc. But excuse me, passive answers like comforts or calms are not active verbs. Those are typically reflective of emotional support animals. But if you're asking the question, you need to listen for those active verbs. So we're talking about alerting, pulling, pushing, warning, opening, sweeping, scanning, waking, etc. And those, again, all reflect service dog tasks. And that, again, is about recognition and response. I noted here sweeping. That's one thing I wanted to talk about earlier, and I forgot. It's a very common thing these days, or quite a common thing these days for veterans to have PTSD animals, and it's a service animal as long as it's trained to perform a task. If it's just performing comfort by being there, that's not a service animal. But if the animal is trained to perform a task, then it is a service animal. And a lot of those PTSD dogs actually are trained to go into a room before the person goes in, and they sweep the room to make sure there's no danger there. And that's for their psychological health, to ensure that is a safe place to go. So that kind of partially answers the question we got through the email, but I'll answer it a little bit more in depth in a minute. So a service animal, however, can be excluded, even if it's a service animal, even if they answered the questions correctly. A service animal can be excluded under these conditions if the presence of the animal would fundamentally alter the nature of the service being provided. An example of this would be a hospital where the handler was having surgery. For instance, a surgical suite, and the animal could not go in there because the hospital could argue that the presence of that animal would fundamentally alter the nature of both the hospital and the surgery itself. Or not the hospital, rather, the surgery itself, but the room, I should say, the surgical room. The surgical room, by the nature of it, has to be sanitary and has to be completely clean. And it's arguable that a dog's presence in one of those surgical rooms is not going to allow the room to be clean anymore. So that can also apply to burn units. ICU units in specific circumstances, you would have to take into account all the different aspects of what's going on with that person in the ICU unit before you blocked the animal from coming in. You can't just blanket block animals from coming into any space. You have to assess each request on its face, and it's a case-by-case basis. So you can also exclude the animal if it's out of control, if it's running around in the room and the animal and the handler's not controlling it. But a bit of barking is not considered out of control because, for instance, some animals actually may have part of their task may be barking. A medical alert dog, for instance, might have to bark to alert their handler to an issue that's coming up with them. You can also exclude it if the animal's not housebroken. If you do exclude a service animal, you must allow the handler to return and take part in the services you provide. So in a court setting, this means, of course, that if a service animal is disruptive or appears to have answered the questions, but they're not really a service animal, you can exclude the animal, but that person needs to be let back in for the program and services you're providing, or for the court case they're involved in, of course. And then the best practice, though, in a situation like that is that the decision should be made by a high-level staff member, such as a manager or director. I wouldn't recommend that that security just decline to allow an animal in or to kick out an animal because it's being disruptive. That usually doesn't go as well, and you might get in trouble legally, potentially. So you can see a picture here of a dog that's eating a waffle off a plate on a table in a restaurant. Obviously, that's never allowed. So I just wanted to give an example of a situation where you can exclude that animal. And you know, you might say, do I have any rights? Of course, you have a right to exclude the animal based on those situations that I mentioned just a minute ago. But you can't charge the service animal any fees that you would not charge to another animal or a person without an animal, excuse me. I mentioned that earlier. It doesn't really apply to the courts, but again, it's part of the law, so I always cover it. If the service animal causes damage to your space or physical environment, you can also charge for those damages. You would, of course, have to follow up and might require a court case to get them to pay, but you do have the right to require that they pay for those damages. Also note that the handler is responsible for all care and supervision of the animal, and the animal should definitely be vaccinated according to state and local laws. But you cannot ask for proof of vaccination under the ADA. As I mentioned, the Fair Housing Act and the Air Carrier Access Act are different. They can, in those settings, require proof of vaccination, but not under the ADA. And then other responsibilities of handlers. The animal must be under control of the handler. Generally, this means that the animal must be harnessed, leashed, or tethered in some way. If the handler is unable to use these tools due to the nature of their disability, or if it would interfere with the service animal's tasks, such as sweeping a room before the owner comes in, then the animal should be under the handler's voice control or under control in some other method. But it is only allowed if it impedes the service animal's task, or if it is not possible for the person to use those tools to keep control of the animal. So here's our quiz, and we can maybe answer these questions in the chat. First question is, a woman enters the building with a dog that has a vest that says service animal. What do you do?
I think you can ask them the two basic questions. What task does it perform? And I forget what the other question was.
Yeah, the other one is, the first one is it required due to a disability? And then the second question is, what task does it perform? Yeah, exactly. So that's the first step. If the animal comes in, does it matter if they have a vest?
No.
No, exactly. If they don't have a vest, you still ask the two questions and you don't assume that it's just a pet or something, because the vest is not required. What if the animal is aggressive toward other people? What happens then?
You can remove the animal.
You can require that the animal be removed, right? So how about a man enters a building with a dog with a vest that says service animal in training? What do you do then?
Ask the same questions.
Yeah, yep, you ask the exact same questions. You must ask the questions. What if it barks repeatedly and won't stop?
Again, you can remove the animal.
Yeah, you can remove the animal. What if it barks a little bit and the handler gets it under control?
That could be.
I would say no.
Right, you have to let the animal stay unless it keeps happening over and over and it does turn into a real disruption. As long as it's just barking a little bit and the handler gets it under control, then you have to let it stay. How about a woman enters the building with a dog with a vest that says emotional support animal? What do you do?
I would say you would still just ask the same questions.
Yes, you ask the same questions because remember I mentioned that there's a situation where some people don't necessarily call their animals service animals because they don't know the lingo and they don't understand the law, but they may be trained to perform a task. So you ask the two questions and you listen for that required active task. Again, if the emotional support animal vest, if that animal or if the handler says that the animal provides comfort when they're anxious, then that's not a service animal. That is an actual emotional support animal, and you can exclude that animal. And ask for or listen for rather the active tasks. So what if the animal is quiet and well behaved though?
That's fine.
Anybody else?
I don't know, if you start making exceptions, then people could bring a rabbit in.
Yeah, you don't make exceptions. Just because an emotional support animal is quiet and well behaved, you do not let that animal in because you'll get yourself in a big pickle if you start letting some emotional support animals in. Because what you do if you do that, what you're doing is setting a precedent that you allow emotional support animals in your building. So you don't want to set that precedent. If you know it's an emotional support animal, if you think it's an emotional support animal, but they answered the service animal questions properly, you still have to let that animal in, but you can exclude it if it's not well behaved. So that's the difference there. Then I just want to go over this Title II complaint. Well done, by the way. Thank you for all your answers. I want to talk about this Title II complaint because this is parallel to something that could happen in a court setting. This is a settlement agreement between U.S. State's Attorney's Office for Western District of Kentucky and Hardin County Emergency Medical Services. And this case was settled in 2018. The claim was that the HCEMS failed to provide emergency medical services to the complainant and specifically refused to allow the complainant to bring his his service animal. Now I'm confusing everybody. His service animal into the ambulance, and they just refused. They didn't make an assessment. They didn't do any of the questions. Nothing. They just refused to allow the animal in. It came down to they were in the wrong because they didn't go through the assessment, and they came to agreement. There was no lawsuit as long as HCEMS ensured that they would comply with Title II of the ADA from now on, and specifically that they did the following. They must assign an ADA coordinator. I know that most of your court offices do have ADA coordinators. If you don't, you need to talk to somebody and get one right away. They needed to establish and publish a grievance policy. If you don't know about this yet, please contact me and I can give you some critical information about grievance policies and how they have to be published. Additionally, they had to develop a training program on Title II. So they had to train all their staff, especially their HR folks. And finally, HCEMS must make reasonable modifications to policies, practices, and procedures. The thing that I really want to what's the word I'm looking for? The thing I really want to focus on here, though, is two things. Both the outcome of this law or of this lawsuit means that it's incredibly important to make the assessment. In every situation, you have to make the assessment. So you have to ask the two questions. You can't just tell somebody they have to leave because they have an animal. If you don't ask the two questions and go through the assessment process, then you are breaking the law essentially, and you could be subject to a lawsuit. The other thing I want to make clear here is that the provider of the service, the emergency EMS service, was actually a contractor. They didn't work for the city, or the county. They did work for the city or the county, but they were a contractor. They weren't actual employees of the city. you are responsible. The court is responsible for the actions of any contractor that is hired. It's very important to understand this. So if you have a sheriff's department or a private contractor that is providing your security services, or if you have other contractors providing other services inside the court, you have to ensure that they know the Title II obligations. Even though a private company is under Title III, because they're working for a Title II entity, they would have to follow Title II for state and local governments. So that's really important that they understand that, because the Title III requirements can be a little different in certain situations. They're the same for service animals, but in some instances they're a little bit different, like with physical accessibility and things like that. So I want to just show you a few resources. I'm not going to go in depth over these, but if you get a copy of the presentation, or if you want a copy of the presentation, we can, I'm sure, provide it to you. But here are some really good resources. Some of these are federal resources, some are more local resources. I think Annie put in the chat a resource directly from the courts here in New Mexico about service animals that covers all the bases. And then that's it. I am ready for questions if anybody has any.
Thank you so much, Jeminie, for such a great presentation.
Sorry, I was so fast. I was trying to keep it short so we could have some question time.
Gotcha.
This is George. I'm sorry, I don't normally look like this, but I'm having issues with my camera. What I would like to know is how effective are the signs, and do you have to put the signs where they're visible for the service animals are allowed?
Yeah, again, service animals are allowed wherever the owner is allowed. So if the owner is allowed in waiting rooms, in bathrooms, and in the courtroom, etc., then the service animal is allowed there too. They're allowed to come through the front door. You should have probably a notice on the front door that says something like service animals are welcome, but pets and emotional support animals are not, or something along those lines, so that it's clear that you have a policy and you're going to stick to it. And Peggy, if we can quickly, I don't know what I did with the questions. Sorry.
No problem. We do have one in the chat, Jeminie, if you want to. This one comes from Amy. Welcome, Amy. She's looking for guidance on the service animal in the court, and her question is related to a request by a judge or other party to limit the animal being viewed by a jury. And the judge is concerned about the size and or breed of the dog causing a reaction as fear by others in the courtroom.
Okay, so yes, you can sort of hide the animal from view of the court, or of the jury, I would assume. You could figure out a way to do that. If you don't want it to walk through the room, you would have to figure out a way to get it through from the backside or something, from the hallway, the back hall where the judge comes through. But if that's that big of a concern, you'd have to find a way to accommodate. You can't just not do it, is kind of what it boils down to. Unless there's absolutely no way that the animal can be in the room without the jury seeing it, I would say you would have to figure out a way to do it. And going through the back door is definitely an option. And then I'm sorry, I forgot the second part of the question.
So whether, the judge can limit the animal being viewed by the jury and out of the judge's concern about the size and or the breed of the animal.
Size, right, size and breed.
Possible.
Now, under the ADA, you cannot exclude an animal just because of its size or breed, and that's a very strict part of the rule. You cannot restrict it, and you have to treat the animal based on what you see in front of you, not based on the behavior of another animal. Like say it's a pit bull and you are afraid of pit bulls, or somebody in the room is afraid of pit bulls. You cannot exclude that animal just because of that. The person with the fear does not supersede the person with the civil rights to have the service animal with them. Again, what I was saying earlier, service animal is an extension of that person. The service animal performs tasks for that person that they can't otherwise necessarily perform, or they are just part of their ability to perform all tasks, any task on their own. You cannot restrict the animal based on the idea that maybe the court can provide the services that the animal provides. You can't do that either. If the animal retrieves objects and maybe that's its only task, the animal still has to be allowed in the court. You can't exclude it just because of the type of task it performs. This is the same case in hospitals. So people who are in the hospital overnight, they can't exclude an animal just based on the fact that the nurses can perform the tasks that the animal performs. So it's the same idea in the court system.
Jeminie, what happens in a case where you have, for example, a service animal and you have an emotional support animal and they're both wanting access to the same area?
Again, the Title II entity does not have to allow emotional support animals. So the idea is that the emotional support animal wouldn't even be there. On the other hand, if you have two service animals, they should be well enough trained that they can be in the same room together. If one of them is aggressive toward the other one, then you would remove the animal that was aggressive. Not both of them, just the one that was aggressive.
Great. We have a few more questions for you.
Uh-huh.
If a service animal, this question comes from James. If a service animal's action is to survey the area, can you require the service animal is leashed after performing their action to show it is under control?
Oh, yeah. The animal can be unleashed only while it's performing its actual task. If it is finished with its task, then it has to be leashed again or tethered. On the other hand, again, if the person with the disability can't perform the task of holding the leash because of their disability, then the animal can just be under verbal control.
Great. This question comes from Meredith. Meredith, good to see you. Meredith is asking, if in a court setting, emotional support animals are not uncommon, should an exception be made for these in court as long as they're well behaved?
The answer really is no. I was mentioning that earlier, because if you allow an emotional support animal in, you're setting a precedent that any emotional support animal can be let in. If it's well behaved, that doesn't really matter. Service animals should be well behaved, should always be well behaved, and if they're not, you can exclude them. But just because an animal is well behaved doesn't mean they're a service animal and doesn't mean that they're covered under the ADA. I recommend following the law specifically because ADA is what applies to court systems. The Fair Housing Act is the only law that covers emotional support animals, and the Fair Housing Act, of course, does not apply in the court setting. So I really recommend that you do not allow emotional support animals in at all, and you can tell that by the two questions. Again, if you hear the correct answers to the two questions, but the animal doesn't appear to be a service animal because maybe it's not as well behaved, maybe it's jumping around under its owner's feet and things like that, keep an eye on it. And then if they if they are ill-behaved, if they're jumping on other people, if they're not sitting still, those sorts of things, then you can exclude it. Even though they answered the two questions correctly, you can still exclude the animal. Yeah, and that's if they answer the two service animal questions correctly. Don't let the animal in if you know that it's an emotional support animal. But again, you still have to ask, if the person says it's an emotional support animal, you still need to ask the two questions just to confirm.
Great, thank you. So we have a few more questions coming in. This one comes from James, and it's actually a question that we have looked at in New Mexico. James is asking, how do you evaluate control when a person, when a person has multiple service animals?
Oh, it's unusual for a person to have multiple service animals. I would say in the court setting, it would be reasonable to limit it to two. The animals must be trained to perform separate tasks. They can't just perform the two tasks. The same task. So you would have to ask the questions about each animal and then kind of go from there. But just a reasonable accommodation would be 1 to 2 1 to 2 service animals. Anything beyond that, I would say, is not a reasonable accommodation because it causes a little bit too much chaos in the room. That's not legal advice, but that's just from what I've heard in all the trainings that I've been in about this topic. It's basically 2 is pretty much the max that you would expect a person to have. And in that situation, they still have to both be well behaved. They shouldn't be playing with each other. They shouldn't be making disturbances, that kind of thing. They should both be laying next to the chair of the owner and be still.
Great. The next question comes from Lucretia. Lucretia, good to see you today. She's asking, can a judge designate where a service animal can be placed in the courtroom?
The service animal needs to be with the owner. So if the owner is, say, up on the stand, the animal should be with them. If the judge says no and wants the animal to be back in the back in the public area somewhere, that's really not a good answer. That's generally not acceptable because the service animal should be with its owner. Again, the service animal is an extension of that person, and they need to have that animal close by. If you are in an unusual situation, or if they're in an unusual situation in someplace they've never been before, and they are separated, it causes a lot of anxiety for the dog, actually. And the dog could potentially end up having their training be essentially damaged by the separation, especially if it's a long separation. They are trained to be with their person and to support their person. So they get super anxiety when they're separated.
Great. The next question comes from Debbie. Debbie in beautiful Hawaii. Aloha, Debbie. She says, aloha, Jeminie. This is Debbie from Hawaii. Can you please go over the provisional coverage for a person associated with a person with a disability? How expansive is this coverage for persons associated?
Can you say the last part again, Peggy?
Yes. How expansive is this coverage for persons associated?
Well, I'm trying to think of an example in the court setting. If a person had a service animal, say a person, well, this is actually 2 things. If a person who was needing to testify had a service animal, then the person with them isn't really affected necessarily, as long as they're allowed to be in the room. And if the animal gets excluded because of poor behavior, for instance, and the person takes it out and comes back, their person who's affiliated with them has to be able to stay too. That person can't be excluded either. So that's the one example I can kind of think of. But the other situation is that you must also accommodate a person with a disability who is with a person without a disability. So if you have a person without a disability who's testifying and their parent has a service animal, you need to let that parent in just in the same way as you would let the person who was testifying in if they had a service animal. Again, it's public access. So if they're sitting in the public area, they have to have public access with their service animal.
Great. Let's see. And Kathy says, if a person needs a comfort animal, most likely a judge would want them in the courtroom.
Well, again, comfort animals and emotional support animals are not protected under Title II of the ADA, which only covers service animals. So the Fair Housing Act covers comfort and emotional support animals, and that doesn't apply in the court setting or in any other state or local government situation. So that animal should be excluded. A comfort animal is, unless the court has a blanket policy of allowing all emotional support animals or comfort animals in, then that's the court's choice. But if there is a pick and choose kind of situation, then that's not okay. You have to ensure that you're following a procedure that you're following your procedure point by point. So service animals are allowed under the law. Emotional support animals are not allowed under the law. If you want to follow the law, then you would not allow emotional support and comfort animals in.
Marlene is asking, what if there's someone with a service animal and there's someone in the courthouse that is allergic to the dog or animals? That's a great question.
Allergies, yeah, allergies do not supersede, just the same thing as fear does not supersede the right for the person to have their animal. The person with the allergy should be separated somehow. The person with the animal should not be the one that gets separated. Again, this is a civil rights law. You cannot separate. You cannot separate the two. Because it's a civil rights law. You have to separate the two, but you cannot move the person with the dog. That person should have full access. If the person with the allergy, then that means that the person with the allergy needs to be moved maybe to the back of the public section or something, or far away in the jury area, as far away as possible. But on the other hand, if the allergy rises to the level of a disability, for instance, that allergy causes asthma attacks, that would then qualify as a separate disability that has to be accommodated. So you'd have to do your best to accommodate both people. And in that case, you would just have to choose which one, try to move both of them far away from each other, apparently. Or maybe if it's super bad, you could maybe have one of them do a remote type, a remote presence to the setting.
Great.
Hi, Jeminie, this is Debbie. I hate to take up time, but I'm still confused about the person associated with the individual who needs the service animal. So the agency would have to accommodate this is a separate person who doesn't need a service animal. They're just associated with the person who has the service animal.
Yeah, the court is a funny setting for this particular scenario.
Okay.
You wouldn't necessarily have to accommodate that other person. The way that is supposed to be kind of understood is if a person, let's say they're going into a doctor's office, if a parent of a child with a service animal goes in with the child, or let's say they go in without the child and without the service animal, just because they have been in that office and the service animal has been declined before, they can't decline the person going in without the service animal.
Okay.
Does that
Okay,
kind of make
that
sense?
makes sense.
Yeah.
It does
So
really make sense with the parent child, right? I mean, we
yeah,
need the parent with the minor.
yeah.
So
Yeah,
yes,
but in
if
the
they're
court
the one with the
system,
animal.
yeah, in the
Okay.
court system, that's going to be allowed anyway, and you don't
Yes,
have to really
yes.
worry about that person being excluded. So that's why
Okay,
it's not a great, there's not a great example for the court
for
setting.
the court. Okay, no
Yeah,
wonder. I was like, oh gosh, that's the first time I
yeah,
heard about that.
it's a
Okay,
different one. Yeah, it's a different
thank
one.
you. Thank you
Yeah,
so
you're
much.
welcome, Debbie, and
Okay.
aloha.
Aloha.
Hello, good to see you, Debbie.
Thank
Um,
you.
Thank you. One more question. What if a state office has a support animal and it's used for victims in cases? Who would that animal have to be with?
Office has a support animal?
Yes. I'm wondering
Um,
what you mean, Marlene, is an emotional support animal, maybe.
Yeah, or that would probably fall under the category of a facility animal or a therapy animal. Those are similar to an emotional support animal, but they've been trained to be in different settings and to provide support for different people. So that would fall under the category of a therapy animal or facility animal. It depends. Different entities call it different things, but those are the two titles for that. And generally, those animals are trained to perform that service. To just be there. It's not a task like a service animal. It's just a service of being there and providing comfort. That's generally what that animal is. And whoever it's assigned to should be handling it. I don't know. That would be something internal to decide who is in charge of the therapy animal. Most therapy animals have a handler that takes them to different settings, and it might not be the office has its own. I would surprise me honestly if the office had its own emotional support animal or therapy animal. Um, but if you hire someone to come in, contract someone to come in and provide that service in the court, then that person would be the handler, and the animal would be left with the person. They can be left with the person, and the handler can walk away, and that's a trained behavior.
Excellent. Well, that's
Do you want to talk about those other questions? I printed them out and now I can't find them. I don't know what I did with them. Those questions that we had with the email.
right.
If anybody wants to stay.
I know that folks are asking if we can get them a copy of your PowerPoint to them. Okay,
Sure. I'll send it to you after we're done here.
sounds good. And if you all want a copy of the PowerPoint, just please email us the request so that we can just respond to your email. Diane is saying our district attorney's office used to have an emotional support animal, and someone in their office was in charge of the animal. And then so that person would bring the animal to the court. That makes sense.
Okay. So yeah, like that animal maybe belonged to that person and was trained to be a therapy animal.
Great.
And that person brought it in. I mean, I can see that happening. But that would have to be a single person that was in charge of it.
Got it. Let's see. I don't
Jeminie,
have that question.
I have a question. I came from the law enforcement side of screening individuals coming into the courthouse.
Mm-hmm.
If in fact a service animal does set off the mactometer, would it be permissible to do a search with a wand? And are we not supposed to touch the service animal?
Yeah, you're not supposed to touch the service animal, but you can use the wand for sure. Yeah, that's fine. Just to ensure that the handler is there and the animal is calm, and it's obviously an unusual situation for that animal. So you just want to be careful not to make sudden moves and things like that. Just because you don't want to scare it, it's not going to hurt you if it's a service animal. But you just want to make sure that you're doing your best not to, scare it into not performing its tasks. But
Okay,
yeah,
thank
the
you.
wand is fine. The wand is fine.
Okay.
Oh, great questions. Thank you, George. Rhonda Blythe says, great training. Thank you so much.
Oh, good.
I join Rhonda's sentiment. Thank you, Jeminie, so much for your time today and your expertise and for answering our questions. We really appreciate it. So all of you, please let us know if you like a copy of the PowerPoint, and we'll be in touch for future presentations. Thank you so much for joining us today.